inception, and NAASF is pleased to have Harry return today to talk about why estate planning is critical for your family and business. Many of you have had questions, and Harry was kind enough to conduct 2 webinars today. He gave one earlier this morning, and today, right now, is the repeat seminar. Besides being a practicing attorney with an alphabet soup of credentials, here are a few related to his topic today on estate planning. He is a certified asset protection planner, a chartered advisor in philanthropy, and a certified financial planner. He has been serving brand name franchisees, CEOs, and their executives nationwide for over 40 years with their asset protection, estate planning, and business planning matters. At the end of the talk today, he will be happy to answer any questions that you might have, probably during the last 10 minutes of his presentation. Here's Harry.
Well, hello everybody. It's great to be back again with the Subway franchisees. We had some questions from this morning, which I will try to address as we go through the presentation this afternoon. Usually when I speak to all of you, I get a chance to see you, so this is a little different, but I think a really good forum for us to be able to share some basic estate planning concepts and ideas. So let's kind of begin by talking about what an estate is and what an estate isn't. You know, it's funny, and we're going to talk a little bit further today about just why some of this is so critical. But a lot of people don't realize that an estate can actually be more significant than you think it is. You know, we think about the businesses, the value of our businesses, the value of land, building, homes, retirement plans, all of our personal property assets, boats, cars, and then surprisingly enough, life insurance. And when life insurance is kicked in, sometimes we have $1–2 million worth of life insurance, our estates can become quite significant. I want to digress for a second and just talk a little bit about what's going on in Washington, because today's talk is really not so much about taxation, but we just need to have it as a backdrop as we move forward. One of the things that's going on in Washington, I think you're beginning to see this, is they can't make up their mind what they want to do regarding estate taxation. Right now, each of us have a $5 million exclusion from federal estate taxes, but that exclusion expires at the end of 2012. And then it's slated, absent congressional action, to drop down to a $1 million exclusion per person and a 55% tax rate. My concern there, and continues to be a concern, is with this, you know, tax the 1% very rich, with Occupy Wall Street and all of us that may own some businesses, there's a concern that the estate tax may return with a bit of a vengeance, so our planning could become very, very significant as we move forward to the future. Now, as you can see, if you look at this chart of the slide, what we have is estate planning, but estate planning is a lot more than just death and dying, and we're going to spend some time today talking about that. Estate planning is an opportunity to provide asset management during lifetime. And as I spoke to many of you over the years, and asset protection during the accumulation years, many of the things that we need to protect ourselves from the creditors, the predators, the liens, the judgments in our country, which is just absolutely litigation mad, some of the same tools that we use for estate planning are similar tools that we use to protect your assets from the claims of third-party creditors, so that becomes part of the overall estate planning process. Planning for retirement is part of estate planning, believe it or not, because we're all lucky we all grow old, and as we grow old, many of the tools that we use have an impact on retirement and the ability to reach retirement funds as well. So I think you're beginning to get the idea that estate planning is just a little bit more than just a will or maybe a bequest. It's important, and we're going to spend time today talking about planning for disability or incapacity, providing for spousal needs, and critically, business succession planning and moving our businesses, our franchises, from one generation to the next. if that's the way we travel, to our key employees, if that's the way we travel, or selling it to a third party, which happens. So inherently, estate planning is used to maximize and transfer stuff to families. The next kind of component that we have is in the need for estate planning. I want to just run through some things with you so you get some ideas. You know, estate planning is not a cheap thing with not planned properly. The estate settlement costs, probate fees, and attorney's fees, which are separate from estate taxes, can take up to 10 to 15% of a gross estate. And we need to make sure that those costs are minimized. And it's also important, for example, we talk about liquidity and cash flow. Again, the government, they don't take franchises. The government doesn't take property. They don't take stock. They take nothing. They take cash 9 months from the date of the second to die of a husband and wife, or if there is not a husband and wife, on the first to die. And if we don't have the liquidity, we wind up having to force sell businesses and or properties. And of course, if we would have had to make forced sales during the last few years when market conditions are poor, or if we have a gun to our head because we have to have it sold within 9 months, we're not going to get the best full fair market value for our assets. So in the absence of good planning, the increased cost of disposition from one generation to the next could range, my God, ladies and gentlemen, an additional 30% in the shrinkage of the value. And we're going to learn a little bit today about trust fund babies, about the people who've not been trained to handle the money or the assets that we're going to give to them. We seem to spend time learning ourselves. Those of us that are all together today on this webinar are taking the time to learn a little bit about and the respect for our assets and moving it from one generation to the next. But surprisingly enough, in many cases, you know, we may be very good at what we do, but the people who are inheriting from us really do not have they just don't have the respect that we have for the assets that they inherit. Okay, so let's talk about something that always makes me scratch my head a little bit as we go along, and that is vacation planning versus estate planning. You know, I've been under the conclusion for many years that probably the most important contract that we write is our estate planning contract, our trusts, our wills. These, we spend countless hours negotiating a lease, a vendor contract, a franchise agreement. We bring in all the lawyers, change paragraph 3, line 4, line 7 to this word to that word in order to make those documents work as best as they possibly can for us in the tough legal environment that we live in. Yet the estate planning documents, which are so personal and represent 100% of our net worth that's being transitioned from one generation to the next, we probably spend more time planning a vacation than we do dealing with those documents. I don't know if it's because we're a little concerned about it's difficult for us to deal with our own mortality, or difficult for us to deal with the fact that we don't think we're ever going to become incapacitated. Maybe we don't like dealing with lawyers. You know, no one loves dealing with lawyers where they point the finger and telling us the things that we should or shouldn't do, or maybe we don't want to spend the money to make it right. But I'm telling you something that's probably no contract is more critical than the contracts that we are going to talk about today. So now we'll circle around a little bit, and what I'd like to do is talk to you about some of the documents that are part of an estate planning process. And we'll kind of start with an advanced health care directive. And, you know, it's funny, when I see over the years people that have, some of them don't even have advanced health care directives, in some states known as durable powers attorneys for health care. It doesn't mean that decisions aren't going to be made, ladies and gentlemen. What it does mean is that the decisions are going to be made by a court, that someone's going to apply for a conservatorship. And one of the things that's really critical is that we need to understand that a no decision is a decision to allow the state to make decisions. So that's one. Now, number two, many of us have advanced healthcare directives. It's kind of like a form document that we picked up from someplace, signed off, naming the people who are going to make healthcare decisions for us. But let's step back for a second and let's think about this document together as we make it come alive. First off, let's understand that, number one, there's probably no more personal document and no document that is used at a time that we are probably at the highest degree of vulnerability. Who's going to wipe our butts? Who's going to change our diapers? What hospitals are we in? Do we live? Do we die? Do we get electroshock therapy? What medications are we on? What medications are we not on? I really can't think, when it comes to myself, what would be more critical than to have a document that speaks at that time when I can't speak for myself. Yet, many of us have not taken the time to think that through and articulate that. So we need to pick the people who are going to make the decisions for us. But before we even pick the people, let's think of some of the things that these documents need to have. First, we do need to think about life support systems and end-of-life decisions, as difficult as they may be, because without that, nobody knows what we want for ourselves, so we should articulate that. It's very important that we let people know whether or not we want to have pain medication administered to us in the event we have a long-term terminal disease, and even if that pain medication could shorten our lifespans. We want people to know that if a long-term care situation came about, we'd want that care to be brought to us at home and not have us possibly shelved off at an institution. All of these various components of how we feel, whether it be organ donation, no organ donation, are all critical to that particular document. So one of the things that we also need to think about is how that document works. And one of the things that we've seen is a big change that's taken place. But those of us that do have those documents, I want you to go home and take a look at yours and see when it was done. Some of us are very happy that we did them and probably haven't looked at them since 2005. But in 2005, what happened is Congress went to work and they passed something called HIPAA. And we all understand HIPAA. HIPAA is the Health Insurance Privacy and Portability Act. That's why we have that yellow line around Costco's pharmacy, so no one can hear the prescriptions that we're getting any longer. So what happens is that if we have a healthcare power that's in effect, let's say prior to 2005, and it doesn't have a release to third-party medical providers for sharing information under both state and or federal law, each state has its own version of it as well, then what happens is that my wife may be holding my power of attorney to make those critical health care decisions for me, but no third-party health care provider is going to give the information to my spouse needed to make the decision. And that doesn't make me feel very comfortable that how they can make a decision in a vacuum without the information. So in essence, ladies and gentlemen, if we don't have that those releases built into those documents aren't worth very much. So we see that. So we all are not operating on the same Windows program or computer programs that we used 5, 6, 7, 8, 9, 10 years ago. But yet I begin to see these documents come up where they're turning yellow and they have that musty smell, meaning that they haven't been looked at for a really long time. Thank God we haven't needed them. The other thing in this one particular document is that we have a tendency sometimes to bring, for example, and have a committee of people, or all your children, because we love all our children equally, or all my brothers and sisters, to make those decisions in the event that I'm unable to make them for myself regarding health care. The problem is we may wind up with a Terri Schiavo situation. If you remember Terri Schiavo, she was the gal in Florida who had the feeding tube, and for 5 years, the husband wanted to remove the feeding tube and let her die with dignity. The parents felt that the lights were on, but even though nobody was home, that she could still have some response and fought that. And for 5 years they fought before they could remove the feeding tube. And the victim was Terri Schiavo. And if we have children or brothers and sisters, and if they disagree regarding a decision regarding our health care, it's not like dealing with money powers, which we're going to talk about in a little while. We are victimized. So a strong suggestion there would be to appoint, a chief to make healthcare decisions for us, and hopefully they will consult with the other loved people that you care about in making a decision, so at least we're not victimized by that. So in essence, what we're saying is that that simple form document that you may have or may not have is a very critical and personal document, and really we need to spend some time thinking about how that gets organized. And every one of us needs a good document like that. The next document I want to talk about in this list of planning for incapacity, and of course we're not even talking about death at this point, is the durable power of attorney. Now, a durable power of attorney is a very interesting document, and once again, basically it's the document that's going to speak when we're unable to speak about who makes the financial property decisions for us, who's going to decide whether or not we re-up the lease, who's going to sign tax returns, who's going to deal with Social Security, who's going to deal with government offices, who's going to deal with everything that we deal with so naturally every single day. The funny part about it is that a lot of us, if we don't have that document, it's the same default. That means we need to go to court and petition for a conservatorship. It'll cost $20,000 to $25,000 to do so. The court does not know who we wanted to make decisions for us, so they're going to have hearings, and there's going to be bonds posted and all the rest because we didn't take the time to effectively put together an appropriate power of attorney. Now, interestingly enough, assuming that we do have one, they come in different versions and different types. And I want to take a few seconds to talk to you about the different versions and the different types. First off, we need to understand that who we write this document for. Now, in many cases, we think we write it, for my spouse, for my kids, to be able to make decisions for us if we cannot. Unfortunately, I think that what we have here is a misnomer. We actually write that document for the people that are going to use it. So, for example, the people that are going to use it are not our family. It's the bank. It's the stock brokerage company. Hey, it's Subway. It's Doctors Associates. These are the people that need to rely upon this document. And let me give you an example to make that easy. Some of us have not taken the time properly to develop a comprehensive power of attorney. We have that single sheet. Everything I hereby grant to my spouse, all the powers that conferred by Texas state law. And so that sounds really good. It's a legal document. It's fine. So now my wife is disabled for whatever reason, and I need to go into the bank and pull out some money out of her bank account using the power of attorney. So I walk into the bank with my one-sheet power of attorney, which is perfectly legal, that says, I hereby confer to my husband, Harry, all the powers available under Texas law. I walk up to the little girl or the guy at the bank, they give it to him and say, here's this my power of attorney, I want to take out the $10,000. They look at it. Now, of course, they have no clue what Texas law says or Texas law doesn't say. So they say, oh, sorry, Mr. Barth, I can't deal with that. Let me call my manager. So now the manager has to come over and says, can I help you? And say, yeah, I'd like to take $10,000 out of my wife's bank account. Here's my power of attorney. And they look at it and they say, well, it doesn't really say what the powers are and what they're not. I'm sure it's okay. I need to send it to my legal department. Now, it's often the legal department which might talk about whether or not the document is sufficient or not. If it's not sufficient, I need to wind up in the courtroom in a conservatorship. If it is sufficient, I've had to go through a big hassle in order to reach those dollars. May I suggest that we change a little bit, that that document should be a comprehensive document articulating all the powers, the real estate powers, the business powers, the banking powers. Every single power should be articulated. So when it says banking transactions, it should say, my successor attorney, in fact, has the power to open bank accounts, close bank accounts, add money, withdraw money, borrow against the account. It makes the document vibrant to the user of the document. So my document, or documents that we write, are 17 pages long, articulating all the powers that our successor attorneys, in fact, hold. But then we go a little further and say, hey, look, Mr. Bank, here's what we have. We have a little thing in here that says, we hold you harmless. You can rely upon this document. We're not going to sue you. That makes them feel better. And then we go a little further and say, but we will also hold you responsible if you do not honor our document under state law, and you will pay for our costs if we have to go through other processes if we had a proper document in the first place. We now wind up with a viable document that's useful. And I think that it's important to understand the difference between having no document, conservatorship, having a document that gives us a full sense of security, and a document that's comprehensive and good. Go home and take a look at yours. Now, there are two other things that are associated with that document that's very, very important, and I don't quite understand. And one of them is that powers of attorney could come into effect at two different times. And for those of you that have powers of attorney and you have a more comprehensive version than the one page, which we already know is not really adequately sufficient, when you go home, I want you to take a look at your power of attorney and see when it comes into effect. Powers of attorney come into effect at two different times. You'll see one which is called a springing power of attorney. It might not have that title on your documents, and one which is called the general durable power of attorney. And the difference is the words incapacity. And the question that comes about is in many cases, and don't ask me why, and I'll explain, it's just non-understandable. Many times you will see your power of attorney says, this power of attorney shall come into effect upon my incapacity. So let's just use my wife and I again as an example. What happens is that my wife, let's say for whatever reason, is having difficulties, losing capacity, unavailable, she broke her leg, she just can't get around to do the things she needs to do. If my power of attorney says that the power of attorney shall come in effect on incapacity, it basically means, it will say, well, what's the definite incapacity? I will now have to go to, in most cases, to get two independent physicians to certify that I know that my wife no longer has capacity. Now, I don't know how any of you are, but it would be a little difficult to take my wife and say, come on, sweetheart, let's go to the doctor to get you certified that you no longer have capacity. It probably won't occur. So what happens is that we need to get, and then sometimes I can't get two physicians to agree that incapacity is an appropriate, whether incapacitated or not. So the power of attorney that we think we have is not being used effectively. Yet, through most of our lives, we've had joint bank accounts, we have co-trustees on our trust, we've done everything together, but by a simple mistake of legal boilerplate, we put up all of these walls and barriers, which makes a very important document not easy to be used. So therefore, in all probability, in most cases, but not in all, because not everything I'm telling today is a blanket statement, you should have a document which is a general durable power of attorney, which is just in effect when we sign it. You can always revoke it, and if we don't trust the people to make decisions for us, we probably shouldn't have them there in the first place. And last but not least, here, under these monetary powers, if we have a group of people, brothers and sisters, children, whoever we have making decisions, it's okay to have a committee because we're only dealing with money. So we don't want to disenfranchise someone who we'd want to have make decisions because then they have to get lawyers to fight us back to get things done. So inherently, this becomes, again, another example of the time and effort that needs to be made and take place in our overall estate planning document. So we've just gone through a couple of them along the way. The next document that I want to kind of cover with you a little bit is to talk a little bit, now we'll finally get to death, okay, the thrilling subject that we're all can't wait to talk about at holiday time. And when we talk about that, we all think in terms of wills. And, when we talk about wills, I want to turn around and discuss a few things. First of all, one of the things that I hear as I go around the country talking about estate planning and asset protection planning, which I do quite often throughout the course of the year, I will ask people, first of all, it surprises me is how many people don't even have wills, trusts, or basic estate planning documents. And for many that do, one of the things that I saw is that people have this misnomer or this understanding. They think that because they have a will that they avoid probate. Now, many of you have heard the word probate, and probably none of us have heard it in a term that's glamorous or endearing. Probate is the legal process in a court that's used to transfer assets from someone who's passed away to the people who are living. It's a process that in many states is long, cumbersome, and expensive. It takes sometimes 2 to 3 years to clear a probate, especially if we have land, building, and businesses that are involved, and could cost up to 4 or 5% of our probate estate in executors' fees and probate fees. This is not estate taxes now. This is just probate fees. And to add insult to injury, it's a process which is public. So come one, come all to the Harry Bart Probate and learn about his wife, about his children's disabilities, who is a good kid, who was a bad kid, learn about the value of his assets. I mean, to me, that is insane. But that's what we have, whether we have a will or no will. A will is a letter of instructions to a probate court judge. No will is the same court, same judge, just at the end of the day, it's decided by state law. With a will, at the end of the day, they will do the best to allow your decisions to be made. So a will actually serves two purposes. It serves or should serve two purposes. One, it should serve as a backup document to a trust. And we're going to learn about trusts in a little while, about all the various good things that can happen in a trust. I promise a little different than the way in which you looked at them before. But what a will does is it basically tells the judge, see, if we have, look at the trust like a shopping bag, we put all our stuff inside the shopping bag. If the stuff is inside the shopping bag, it'll pass without probate from husband to wife, from parents to children to brothers to sisters. No probate. We never have to go to the court. We never have to deal with the lawyers. Very important and private. But if we have assets that for some reason or other that we didn't put into the trust, and I see this all the time where people spend a lot of money putting together a good comprehensive estate plan, and then I'll find that your LLCs, your corporations, your buildings, and many of your assets have not been titled in the name of the trust, and as a result of that, they are heading to probate. So we understand that a will now should serve only one purpose, to basically say for any assets that we missed putting in trust, those assets have to go to probate through that process, just those assets, and it tells the judge at the end of your long, arduous, and expensive process, why don't you go give it to the trustees of the trust? They know what to do. They know my story. They know my game plan. So I think that it's really important to understand that a will serves as a backup document to the trust. Hence, sometimes you've heard the name pour over will. It pours over into the trust. The other thing is that, and it's on the slide that's up on the computer, is the issue of guardianships. And it's within the will that in most cases that we name the guardians for any minor children. Now, this is very interesting. I always turn around and I ask clients, I said, you know, what is your most precious commodity? And the vast majority of the time they'll turn around and say, hey, Harry, you know, it's the kids. My kids are my most precious commodity. And I said, and how much time and effort did you spend dealing with the guardianship for your children? Well, not much. We named my brother as the guardian, or my sister as the guardian, or my parents as the guardian for our minor children. And then I'll ask kind of a stupid question that goes so far in saying, I'll turn around and I'll say, okay, did you even ask them? Do they even know that they're named as guardians? And many times they haven't. But I want you to think about something this way. I want you to think about the fact that your brother, is married, he's got 3 kids, the house is barely big enough for them now. They got a car, they got all 2 passengers at the front, 3 kids in the back, and maybe they can turn around and just fit their family in there now. Then God forbid something happens to you, and your 3 kids or 2 kids show up. There's not enough room in the house for them. They can't even put them in the car to go out on a Saturday night to take them for dinner. A family trip or family vacation now becomes a much more significant problem, and the kids came without any funding. Wouldn't it be much better to have a significant discussion with the guardians about what things that you want to deal with, the religious issues, in-law issues, geographic issues, and not impose an economic hardship by saying my children come with the trust fund, my children come with the ability that if you need a bigger house to take care of them, it's available. If you need to get bigger cars to take the children around, that's fine. If you need to go on a family vacation, that's fine. That's taken care of. We want you to provide good guidance for our children. That's why we've selected you as guardians. That conversation and that type of funding needs to be done whenever you're dealing with guardianships. And the other thing that's funny about that is that you will turn around and I'll see simple guardianship arrangements that look like, okay, I have my brother and my sister-in-law who are going to be the guardians for our young children. And then I'll say, okay, that's great. And what happens if your brother and sister-in-law get divorced? Do they stay with brother or sister-in-law? Oh, we didn't think about that. Who's preferred of the two? Well, brother-in-law. Okay, what happens if brother-in-law dies? Do they stay with sister-in-law? Oh, no, no, I want them to go to my other brother and sister-in-law. That sounds fine. So here's what you're telling me, that the children lost their parents. They've now bonded with a new family and their new cousins. The tragedy has befallen that family. Now we're going to rip them away from those other people and move them to another family yet again. Say, oh, I didn't think of it that way. How much time have we spent on guardianships? I think it's very, very, very important. And all these issues can be resolved with a little bit of planning. Who's preferred, how it works, how it goes. So I think that a will serves as a great backup document for our trust, and it serves as a great opportunity to really get into the discussion of guardianship for any minor children. Now, getting away from that, I just want to move over to the document now that is critical that we'll spend the next half hour together on, and we'll talk a little bit about trusts. All right. Now, living revocable trusts, for some reason or other, I don't know where the old wives' tale came from, but just to start, a couple of things to know. Living revocable trust provides zero asset protection for us. So if we create our living revocable trust, we put our assets inside the living revocable trust. It provides zero asset protection for us. That's not necessarily the case with our children. But we have understood some things. Some things when we set up those trusts is one, the most, believe it or not, what you may not be thinking about, the most important thing that we gain is privacy. So we've tried to work real hard to be private amongst our family throughout our lifetimes. I think it's very important to make sure that we've maintained that privacy in the event, God forbid, of death. So I think the will provides privacy. It avoids the probate. It avoids the costs that are associated with probate. So trusts are extremely very important. I think I mentioned will. It's a trust that provides those kinds of things. And they're relatively easy documents. During your lifetime, you and spouse, or you only, you are the chief cook and bottle washer. You're in charge. I have no special forms to file, no special tax returns that need to be filed whatsoever. And so it maintains the full level of flexibility. One of the things that are very important, however, in the trust are the things that happen in the event of death. And so the first time that the trust really begins to take some kind of action is if we lose one spouse or upon death. Now what happens is that the way the federal tax laws are currently established, and the estate tax laws, which we don't know it's going to happen again, remember, at the end of 2012, each of us has an estate tax exemption. Right now it's $5 million. So if you're married, it should be $10 million for husband and wife. But, you know, it's not necessarily automatic where it goes from one to another. So therefore, the first things that the trust does is it turns around and it makes sure that we take advantage. When you see these A, B, and C provisions in trust, it takes advantage of the various different estate tax provisions to make sure we get both for a husband and a wife. In addition, it provides some control to make sure that our assets go to the children. In the event if I die, it goes to my spouse, and upon my spouse's death, it goes to my children, not to her new husband or to save the whales. Those are the types of things that happen as far as taxation is concerned and control between spouses, plus the continued privacy and the avoidance of probate. A living trust is very, very, very good. It avoids probate, as you can see, helps control distribution, can manage fees and taxes, and we'll talk about professional management and avoid probate. One of the questions that came up has to do with titling and trust funding. And in titling and trust funding that we have, you can see on the funnel that I have on the screen is that in order to avoid probate, we see personal property, retirement plans, stocks and insurance, business insurance interests are all pouring into this funnel that we have available for us. Now, one of the questions that came up this morning was that Doctors and Associates does not allow you to place your franchise agreements inside a trust. Now, let's kind of take that apart a little bit and tell you how that's worked with all the Subway franchisees we work with. What we can place in trust are all of the various, most of you are working in the form of an entity, an LLC, a corporation, or even a partnership. all of the furniture, fixtures, equipment, all of the various different assets that you might have are associated with the business, those entities are placed in trust and avoid probate. The franchise agreements, although they are issued to you directly, the franchisor's concern there is significantly that we do not have a successor or a successor trustee who's not trained and not a qualified operator now beginning to operate under the trust agreement Subway franchise restaurants, which I don't think in a way is very good for the system, because you do not want that. You want quality people to maintain the standards that are involved. But it's also important to the franchisor that they have proper people that are in place. So the business itself would avoid probate. The franchise agreement, there's a certain amount of time in your franchise agreement to have the business replaced with a qualified operator that's in there. So the operational part of the operator is not necessarily an issue, because the business, furniture, fixtures, equipment, and all the other things associated with it are already would be in the trust. So it's not a calamity that we don't have the franchise agreement itself assigned to the trust, because that's a collection of rights and the use of various different marks along the way. One of the things that we will try to do, or we've been trying to do and will continue to try to do, is to work with the people at Doctors Associates and incorporate by reference your franchise agreements into your estate plan, saying that we promise that we will always have qualified people running a franchise operation. And I think with that, the franchisor will be maybe a little bit more flexible in the allowing of the assignment of franchise agreements. We've done that for many other major franchise organizations. So we'll take a look at that. One of the things, and we're going to talk about some great opportunities in the trust in just about 1 minute here. But one of the things that a lot of you deal with is joint tenancy of property. And joint tenancy of property is probably the worst way to deal with property from an estate tax perspective and from an asset protection perspective. You may say, well, we own our house, joint tenancy, husband and wife, or between brother and sister in our business. And the reason that you've done joint tenancy was to avoid probate, because what happens is automatically by operation of law, the assets move from one party who's died to the other. We don't have any legal interference to get anything done. Remember, we achieve the same thing through the use of a living revocable trust. But the difference is with joint tenancy and property is that if you have a joint tenant at the other side, they get one. It doesn't matter what your will says. It doesn't matter what your trust says. It goes to the joint tenant. And we may very easily, unintendedly, disinherit a beneficiary. I'll give you an example of that we didn't talk about this morning, where a woman, a mom, held a joint tenancy asset with the daughter, and the daughter was a franchisee. And mom did that, so when mom dies, she wanted the house to go to daughter. And what happened was the daughter's husband got in fiscal, was gambling, got in fiscal financial hot water. Then they got in troubles with guarantees on leases. So the daughter and husband wound up in financial hot water and wound up having to file a bankruptcy. It was just absolutely terrible. But of course, because she was a joint tenant with mom and considered to be 100% owner of mom's property, as mom is considered to be 100% owner as well, mom's house was actually brought into the bankruptcy and liquidated. Wow, that would not be a real good thing for your mother-in-law. If your mama lost her house because she was trying to avoid probate, which she could have easily done with a trust and not have had that problem. So just understand that these things need and require some time, some effort, and some problems. But I want to now move to the things some really nice things that can happen with our living revocable trusts, and some of the things, but we need to understand the invaders of the estate. It's kind of like, it sounds almost like a science fiction thing. And the invaders of the estate are the IRS via estate tax problems. I think we all understand that. We also talked already a little bit this afternoon about probate via the lack of planning, which is totally and completely avoidable. And now I want to talk a little bit about the next three: a beneficiary's creditors, a beneficiary's divorce, and a beneficiary's overbearing spouse. I said this morning, and we'll do it again, for those of you that may have remembered Johnny Carson. Johnny Carson used to do with Ed McMahon a skit on late night TV. It was called Karnak. And in Karnak, Johnny put on the turban, and he would hold an envelope, as you know, up against his head, and Ed would ask the question, and Johnny would know the answer to what was already inside the envelope. So let me do a little Karnak with you when it comes to a living revocable trust. What if I had to put it up against my head? It would say, husband leaves everything to wife, wife leaves everything to husband. There's A, B, and C provisions inside. So, and then upon the second death of the spouse, it's divided equally amongst our children in a three-stage distribution at 25, 30, and 35. Probably caught 65% of every trust that was written in America under those very simple, very ordinary, very mundane terms. And boy, have we all missed the boat when it happened that way. I have no idea why we do it so clinically at the most important document that we ever write. So for example, one of the things that we can do, instead of the 25, 30, and 35, although there's no asset protection for us in creating the trust for our own assets, under U.S. law, if our beneficiaries receive the assets in trust, they are completely protected from the claims of third-party creditors. Now, this is very, very interesting. So what would happen is if I left money to my son in trust, let's say for a life rather than 25, 30, and 35, and it set that trust up properly, he can have inside his trust his home, he can have business, he can have vacation home, he can have stocks, bonds, cash, pretty much everything that he has outside of trust, he can have inside that trust for him. But the difference is now if he crashes the car and kills two people and God forbid has a judgment against him for $5 million, no creditor can reach inside to his trust and reach his assets. Why would we not leave our children with the ability to have their assets completely protected from the claims of third-party creditors? Because that's the way mom and dad set it up. And you say, hey, but then, you know, don't they have the use of the money, blah, 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 blah. Well, let's examine that a little bit in just one moment. Sometimes the biggest creditor that our child has is their spouse. And matter of fact, half of all spouses become creditors. And it would be very nice to know that the money that they inherited from the parents was not available to that spouse to meet spousal support needs or any other needs because it was set up properly in trust. The other problem that we have is what we call the overbearing spouse. And this is an interesting scenario that occurs when, let's say, my daughter inherited X amount of dollars, and now comes her husband saying he wants to open up, you know, a kangaroo meat restaurant, and because she loves him so much that she needs to give him the money. So we can have a spouse that has a tremendous amount of influence on one of our children, and as a result of that, the assets that we worked so hard and developed during our lifetime can be lost to frivolous and terrible spending. I have a slide coming up on that as well. Also, let's take a look down for a second. You'll see children with drug, alcohol, or other addiction problems. One of the first things I look at when I look at a living revocable trust for the beneficiaries, for any beneficiary, if those beneficiaries have drug, alcohol, or addiction problems, and then we turn around and hit them with money that they've never understood, never handled before in their life, they're just going to take that money, buy a fancy car, and kill themselves. So I think it's very important that we make sure that the transition from one generation to the next is completely articulated and well thought out. So now that we have those silos, let's say for the children for life and then for the grandchildren for life, the next question comes in is how does the children manage or gain control? I think first important is we need to decide whether or not the children should manage and gain control. But even if they are, what we can do is we can do it in terms of power rather than in terms of taking assets out of trust. So in my case, for example, my children can each be investment advisors to their trust, and that will allow them to interface with the trustee. That will allow them to, you know, make suggestions on how assets in their trust should be invested. And then the trustee would go along with it or not go along with it because the trustee may have the experience that my children do not have. Second of all is I will turn around and at some age, you know, instead of the 25, 30, and 35, just change it. 25 years old, you become investment advisor. At 30 years old, you become co-trustee with the current trustee, so that gives you a complete veto power. And at 35 years old, maybe you can even become the trustee of the trust, or we can have an independent trustee and you can become more involved with everything that they do. This gives us the opportunity to have the stuff going to our grandchildren, stay completely asset protected from the claims of third-party creditors, give our children someone to bounce everything off of and getting things done, and not necessarily having to turn around and subject those to all of those various different claims. So now the question comes up is, okay, well, who might be that trustee? You know, we heard about all these things with trustees, and maybe let's think of an independent third-party trustee like Wells Fargo, a private bank, or Northern Trust, or First American, or Bank of America. You know, you would say, okay, but aren't those large, impersonal organizations that really don't understand my family? And I say, well, first of all, at this point, we have trustees in there to make sure that the things that mom and dad wanted to do are being carried out and taken care of. But then there was Uncle Joe. So let's take a second and talk about Uncle Joe. Uncle Joe may be your trustee right now. So here's the deal. You have 3 teenagers, and then there's Uncle Joe. And Uncle Joe is you named as trustee. Uncle Joe has complete fiduciary responsibility for investing those 3 teenagers' money. If he messes up, the 3 teenagers are going to sue him. Because the relationship, which was good when it started with Uncle Joe, the trustee, is not going to last very long. Because Uncle Joe is entrusted with the fact of telling 3 teenagers, boys and girls, well, no, maybe you can't take a trip to Europe with someone. No, I don't think you can get that fancy sports car. Maybe we can get a more functional car. No, you really can't afford to live in that apartment in downtown New York City somewhere. You can't. So Uncle Joe is constantly saying no to children who do not have the fiscal responsibility yet to manage their own money. So Uncle Joe becomes the villain, and it doesn't take long before. And by the way, Uncle Joe shows up. It's time for your annual drug test, and so here we go. So Uncle Joe has fallen into poor graces. And Uncle Joe had a great relationship when we started, and we did this to Uncle Joe. Now, if we had a professional trustee in place, and I'm going to kind of move the slides over here a little bit. You like this one, don't you? The betas of the estate, the kids and stuff. Look at this. The average inheritance is completely consumed within 1 year. That picture just says 1,000 words, doesn't it? Bad financial decisions, vulnerable to unscrupulous people. So when we get over here a little bit, I want to just talk about the value of a corporate trustee is where we're at. Experience and accountability, commitment, longevity, continuity, objectivity, and follows regulations. Very important, I think, for what we want to accomplish. But the thing that's really critical, I think, to me, is that Uncle Joe becomes and holds a position which is new, and that position is called the trust protector. He has the ability to fire the trustee and replace them with another trustee if they're not serving the beneficiaries well. That puts the power back in the family where it belongs. Uncle Joe has the ability to override the trustee. So between the combination of the fiduciary duty of the trustee and the input of the children as they're learning and growing and the input of the protector, we begin to develop a very significant estate plan that has great opportunity for our children. The other thing that I failed to mention is that we have 2 other very narrow things that we need to discuss just for a second, and then we'll take some questions and conclude. But one of the things is that if we have a child that has special needs, and if they're getting government benefits or receiving state benefits to help them because of their disabilities, and God forbid we lose a parent, then what happens is that the moment they inherit the assets from the parent, they will be disqualified from all very valuable government benefits. God forbid, a child on dialysis or other types of things. So until they spend all their money down and they're broke again, and then they can reapply for government benefits. Knowing this in advance, you can set up what is known as a special needs trust for that child or those children, and those dollars can be used to enhance their lifestyle and make their life better without losing government benefits. And the other thing, too, that we didn't mention a little earlier on is that the United States tax code discriminates when it comes to estate taxation. There is no estate tax between husband and wife unless a husband and a wife are non-U.S. citizens. And if they're non-U.S. citizens, the estate tax is due on the death of the first spouse and not the second spouse. That also needs to be dealt with in an estate planning situation, and we do that through the use of what's called a qualified domestic trust. So in summation, I think I've given you a really good tour of how these documents can be living and viable. They help to maximize affordability laws, to provide for surviving spouse and children, protecting beneficiaries' inheritance, protecting special needs children, providing for your own incapacity in retirement, dealing with succession planning and dealing with taxation, liquidity, and in many cases, charitable consideration from being successful in our businesses to being significant to help others in the future. All of that is part of it. As I always do, I will provide everyone, I think there are a number of people online with us today, with a complimentary consultation for everything that we do. And we can spend an hour chatting at the end, answering any individual questions that you have. It's right up there on the board. You can send us an email or give us a call, and we will follow up and help you. We have a very, very good working relationship with you at Subway, and I think we can help a little bit. So I will now see whether or not any of you have any questions that we might be able to take online in the time that we have. So I'm going to turn the volume up here, so if you have any questions, that'd be great. If not, I look forward to hearing from each of you, and I sure hope that you realize that estate planning is not so simple, yet it's also not so clinical. It really opens a great opportunity and probably the most important contract. And thanks for allowing me to spend time with you as always. So I'm looking to see whether or not we have any questions. So Tina, could you moderate this and take over? Thank you. Oh, and one other thing too, I want to make sure that if you enjoyed this webinar, I know NAASF is going to have more webinars for each of you over the months and over the years to come, and NAASF and I all wish you a real great holiday season. Okay, thanks.
Okay, it looks like there does not seem to be anyone on with questions at this time. Again, if you do have any follow-up questions, you can go ahead and send us an email or contact our company or email NAASF, and they will be able to direct you to us. Thank you again. Have a good day and a happy holiday.